Ever pour your heart into a project, like spend days on a song or finally perfect that logo design, only to stumble across it online, plastered everywhere, and you're like, hold up, did they even ask?
Yeah, it's sadly more common than you'd think in our digital age. No creator should have to deal with that sinking feeling.
It's like that feeling of someone raiding your fridge, but they're making off with your creative spark instead of your snacks. But hey, that's exactly why we're diving deep today, right? We're all about equipping you with the knowledge to guard those precious creations.
Absolutely. Consider this your crash course in online defense, specifically with the DMCA, the Digital Millennium Copyright Act.
Your secret weapon against those digital art bandits. So let's jump right in. Let's say, hypothetically, someone loves my latest blog post a little too much. Copy, paste, boom, my words are the star of their website. What's my move? Can I actually do something?
That's where the DMCA takedown notice puts onto the scene. It's basically a formal letter, but digital, where you're telling the website owner, hey, that's mine and you're using it without my permission. Down it goes.
Yeah. So it's not as simple as shooting over a quick, not cool man message.
Well, you could try, but the DMCA's got a more, let's say, structured approach. It lays out specific elements your notice needs to have to be taken seriously, kind of like a legal recipe. Helps the website understand what exactly needs to disappear.
Okay, so more like a formal dinner party than a casual potluck. What are some of those must-have ingredients?
For starters, you absolutely have to clearly identify the copyrighted work that's gone MIA. Think of it like reporting a stolen car. You wouldn't just say, my car's gone. You'd give them the make, model, year, maybe even that dent you've been meaning to fix. Be specific.
Got it. So providing the creative equivalent of a police report, details and all. Then what?
Then you point them to where this digital crime is happening, the exact URL. It's like saying, see, right there, they're wearing my stolen lyrics. Then comes the formal declaration that you're the rightful copyright owner, or at least you're authorized to act on their behalf.
Proof of ownership showing you're not just a fan claiming their favorite song.
Exactly. You have to genuinely believe the use of your work is unauthorized, of course. We're talking about clear infringement, not someone just having similar vibes. It's about protecting what's yours.
Right. Playing by the rules is key. But let's say, hypothetically speaking, I get a little overzealous, maybe misidentify some content in my eagerness. What kind of trouble are we talking? Asking for a friend, of course.
Oh, this is where things get real. A DMCA takedown notice isn't messing around. You're signing under penalty of perjury, so accuracy is your best friend. False claims can lead to some not-so-fun legal consequences, including a hefty hit to your bank account. There was this case a few years back. A photographer mistakenly issued a DMCA takedown for an image that was actually public domain. They ended up paying a hefty price, literally.
Oof, that's a cautionary tale for sure. Definitely double-checking those facts from now on. So, DMCA notice, carefully crafted, every detail accurate. Where does it actually go? Do we have to put on our detective hats and hunt down the infringers ourselves?
Thankfully, no. Most websites have a designated agent just for this, like a special mailbox for these legal notices. You can usually find them tucked away at the bottom of a website, in the footer, or on a page dedicated to copyright.
A digital drop-off box for It's the Law notices? Easy enough. But what about those smaller sites or personal blogs? They probably don't have a whole legal team waiting for these, right?
Good point. It can get a bit trickier with personal websites. You might need to do some digging, figure out their hosting provider or the company managing their domain name. They usually have the power to remove the content or even take down the whole site if it's a repeat offender.
Okay, so there's always a way to address the situation, which is good to know. But after we hit send on that DMCA notice, what then? Do we just cross our fingers and hope for the best?
Ideally, the website owner sees it, has a moment of realization, and promptly takes down your content. Problem solved. But in reality, it doesn't always go down like that.
Because who doesn't love a little online drama, right?
Right. Sometimes that notice might get lost in the internet void, ending up in a spam folder somewhere, never to be seen again. It happens. But if you don't see any action after a reasonable amount of time, don't panic. There are ways to escalate the situation.
Okay, so we're not waving the white flag just yet. What's the next move in our digital defense playbook? So we sent that DMCA notice and crickets. What's our next move? Do we just accept defeat, or is there a way to fight back?
Well, before we launch a full-blown digital counteroffensive, let's try a gentler approach first. Start with a polite follow-up, just in case the first one got lost in the internet abyss or maybe accidentally ended up in their spam folder.
Giving them the benefit of the doubt. Makes sense. But what if they're straight up ignoring us? What are our options then?
Okay, then it's time to step things up a bit. Many platforms have a dispute resolution process. It's like taking your case to a digital mediator, someone neutral who can look at the situation and hopefully nudge things in the right direction.
So there's a whole system in place for this. That's reassuring. But what if the infringer decides to play hardball? Like, they hit back with a counter notice claiming they have the right to use my work.
Well, that's when things can get a bit more, shall we say, legally interesting. If they file a counter notice, the platform might temporarily put your content back up while they investigate. So now the ball's in your court. You could choose to let it go or gear up for a legal battle. But if you're thinking about lawyering up, you got to act fast. There's usually a limited window, like 10 to 14 days, to file the lawsuit and stop the content from being restored.
Okay, so things just got real. But let's say, hypothetically, the case goes to court and we win. What does that actually look like? What's at stake here?
Winning a copyright infringement lawsuit? Well, if the court's on your side, they've got a few tricks up their sleeve. They can issue what's called an injunction. Basically, it's a formal cut it out from the court, ordering the infringer to stop using your work immediately. And I mean immediately and permanently. No more ifs, ands, or buts about it.
So it's not just a slap on the wrist. There are real consequences.
What about the financial damage, though? I mean, we're talking about lost income, right?
Absolutely. The court can order the infringer to pay you damages for the financial hit their little stunt caused. We're talking lost profits, maybe if they were selling your work, or even the money you could have made if they hadn't been undercutting you.
Right, makes sense. But isn't it true that sometimes it's not just about the money? Like, if someone uses your work without permission, can't that hurt your reputation too?
We hit the nail on the head. Imagine you're a photographer known for your incredible wildlife shots. Someone decides to use your photo without asking, of course, to promote, say, a hunting expedition. That's got to hurt your brand, right? Could even alienate potential clients who value your ethics.
It's like they're putting words in your mouth, or rather, your work, without your consent. Not cool.
Yeah.
Definitely not. And the good news is, these kinds of less tangible losses like damage to your reputation or even your future earning potential can also be considered when the court's figuring out those damages. Of course, legal battles can get pricey themselves, but hey, if you win, the court can order the infringer to cover your attorney fees and those court costs on top of the damages.
So it's not just about recovering what you lost, it's about making sure creators are compensated fairly and protected. That's huge. Speaking of experts, our research uncovered some really interesting insights from a Web3 lawyer and mediator, Mitch Jackson. Ever crossed paths with him?
Mitch is great. He's doing some amazing work in online content creation, always fighting for creators' rights. He really stresses respectful, open communication when you're dealing with copyright issues, even if you're ready to throw your laptop out the window.
So maybe hold back on those all-caps rage-filled emails.
He definitely advised against that. Mitch is all about keeping things professional and productive. You know, he always says it's crucial to truly listen to the other party, try to understand their perspective. Even if you completely disagree, just that effort to understand can really dial down the tension.
Like they say, you catch more flies with honey.
So for our listeners who are intrigued and want to dive deeper into Mitch's wisdom, where can they find him?
Definitely check out his LinkedIn profile. He's always dropping insightful articles and engaging in some really thought-provoking discussions there. Plus, he's always sharing super valuable advice on navigating this whole intersection of law and technology.
Perfect. We'll make sure to include a link to his profile in the show notes. So far, we've covered a lot: DMCA takedown notices, potential legal outcomes, but there's one more piece of the copyright puzzle we have to talk about. Fair use.
Ah, yes, fair use. It's easily one of the most misunderstood and often misused parts of copyright.
It's like that blurry line everyone's always tripping over. So let's clear things up. What does fair use actually mean when we're talking copyright? In a nutshell, fair use allows limited use of copyrighted material, and you don't even need permission for this. But the catch is, it has to be for specific purposes. We're talking commentary, criticism, news reporting, educational stuff. For instance, imagine a film critic using a short clip from a movie in their review. That generally falls under fair use because it's for analysis critique.
So it's not a free pass to use anything you want. It's about finding that balance, protecting creators while still allowing for free expression, that flow of information. But how do you know if something actually falls under fair use? It seems like a very fine line to walk.
Oh, you're telling me. It can get tricky. Courts usually consider 4 factors when evaluating fair use. But, and this is important, those factors are open to interpretation. That's why you got to be extra careful, err on the side of caution, especially if you're not 100% sure.
So consult with a copyright attorney when in doubt.
Always a good move. Getting legal advice early can save you a lot of headaches later on. And remember, misunderstanding fair use isn't a valid legal defense. And abusing the DMCA by filing false claims, that's a recipe for disaster.
Good thing we're having this conversation then. Now, we've been mainly focusing on US copyright law, but the internet's global, right? What if someone in another country decides to borrow my work without asking? Does the DMCA have any power in those situations?
Ah, the joys of the global village. It's true, the DMCA is a U.S. law, so it directly applies to U.S.-based companies. But that doesn't mean you're out of luck if someone outside the U.S. is, let's say, inspired by your work a little too much.
So there's still hope for international creative justice. But what options are out there for creators dealing with copyright infringement that's crossing borders?
You'll be happy to hear that many countries have realized how important it is to protect creators online. They've got their own laws, many similar to the DMCA. It's like a global network of copyright shields, each protecting creativity in its own region. A worldwide web of copyright protection. I like the sound of that. Let's do a quick world tour. What about the European Union, for instance? What's their take on copyright in the digital age? The EU means business when it comes to copyright. They've got a two-pronged approach. First, the e-commerce directive. It's like a safety net for online platforms, meaning they're not automatically liable for copyright infringement by their users as long as they're following the rules. But then they've got the copyright directive, and Article 17 of that really steps things up. Platforms in the EU have to be much quicker about responding to infringement notices, and there's even a requirement for them to actively try and license content.
Wow, it sounds like the EU isn't messing around. They're really staying ahead of the game. What about our neighbors to the north, Canada? How do they handle copyright infringement?
Canada's got a slightly different system called notice and notice. Basically, instead of making platforms instantly take down content that's allegedly infringing, they make internet service providers forward those notices to the users in question.
It's like a friendly tap on the shoulder from the internet provider saying, hey, someone thinks you might be stepping on some toes here. Might want to double check that.
Exactly. It puts the responsibility on the user to address the issue, which can sometimes prevent a much bigger legal headache later on.
I like that. It seems fair, balancing the rights of both sides. Any other countries leading the charge in online copyright protection?
Oh, tons. Australia, for one, updated its Copyright Act back in 2015. They've got a system that's pretty similar to the DMCA's notice and takedown process.
Okay.
Plus, they've got the power to issue site blocking orders against websites that are notorious for copyright infringement. They don't tolerate those repeat offenders.
No playing around there. Any other copyright havens we should have on our radar?
Definitely. The United Kingdom has a two-pronged approach, too, with its Copyright Designs and Patents Act. They've got the notice and takedown, but they've also got legal frameworks specifically for those who just don't get the memo the first time around, those repeat offenders.
Like, okay, you had your chance, now it's time for the real consequences. So no matter where you are in the world, there's some kind of legal framework to help creators deal with online copyright issues. That's good to know. But with all these systems, especially the automated ones, I imagine things must go wrong sometimes, right?
Oh, absolutely. Technology is a powerful tool, but it's not foolproof. Automated systems like YouTube's Content ID, for example, are super helpful, but they're not perfect. Sometimes they flag content by mistake, so perfectly legitimate content gets taken down. It's like accidentally throwing away a priceless diamond because you thought it was a fake.
Oh no. So what happens if your content gets caught in that algorithmic crossfire? Is it a nightmare to get it back?
It's definitely frustrating, but it's usually not a lost cause. Most platforms have a way to dispute these things. You appeal the decision, show them you own the rights, explain why you think the system got it wrong. It might take a bit of time and effort, but you can usually get things sorted out.
That's reassuring. So you're not completely powerless. So far, we've talked a lot about protecting your work when someone else uses it without permission. But what about those times when you actually want to collaborate, share your work with others? How does copyright play into that? So let's say I'm all about collaboration, ready to share my work. How do I make sure everything's above board, legally speaking, so it doesn't turn into a creative tug of war later?
That's where clear communication comes in. And honestly, having things in writing is your best friend. Think of it like this. You're building a creative partnership, right? You want that foundation to be strong, and that's where those legal agreements come in. If you're teaming up on a project, hash out who owns what rights from the get-go and how everyone involved can use the final product. Get it all out in the open.
So, like, drawing up the guidelines for the creative sandbox, making sure everyone knows who brought what toys to play with. What are some ways creators can protect themselves when they're in that sharing mood?
Licenses, my friend. Licenses are like those permission slips for using copyrighted work. And there's a whole variety out there, some stricter than others. You've got Creative Commons, which gives creators flexibility in how they share their work. Or you can go the more traditional route with a custom agreement, drafted up just for your situation.
Sounds like having even a basic understanding of licenses can be super valuable, especially for creators who love to collaborate but also want to keep their creative control.
Absolutely. Knowledge is power, especially when it comes to your rights as a creator. And remember, if you're ever unsure about the best way to protect your work or find yourself in a tricky copyright situation, don't hesitate to reach out to a copyright attorney. They're like those legal guides who can give you advice tailored to your specific needs.
It's like having a copyright compass to guide you through this ever-changing digital world. Well, we've covered a lot of ground today. The ins and outs of the DMCA, a global tour of copyright laws, even dipped our toes into the sometimes confusing waters of fair use. As we wrap up this deep dive, what's that one big takeaway you want our listeners to remember?
Honestly, the most important thing is this. If you're creating something, music, photos, videos, designs, even that killer business proposal, be proactive. Understand your rights and how to protect them. Get familiar with the copyright laws in your country. Think of it like this. Your creative work is valuable. You insure your car right. Well, copyright is a way to ensure your intellectual property.
Love that analogy. Like they say, an ounce of prevention is worth a pound of cure. Always easier to protect your work up front than to deal with the headache of infringement later.
Couldn't agree more. And remember, copyright isn't about stifling creativity. It's about creating an environment where creativity can thrive. When we all understand and respect copyright, we're all contributing to a richer, more innovative digital world.
Beautifully said. A huge thank you for taking this deep dive with us today. You've given our listeners a powerful toolkit to navigate the world of online copyright. And to all our listeners, keep those creative sparks flying. Until next time, happy creating.